Good morning, dear shareholders, ladies and gentlemen. It is an honor for me to address you again at this extraordinary general meeting of shareholders. First of all, and before going into the development of this event, I would like to welcome you on behalf of the Board of Directors and on my own behalf, and thank you for your presence and the trust you place in Indra. I would also like to welcome all the shareholders who attended by telematic means and thank those who, unable to attend, have granted their proxy or exercised their voting rights by remote means. For Indra, the participation of its shareholders in the general meetings is very important, and it is very gratifying to see the interest shown in participating in this event. The possibility of attending the extraordinary general meeting has been made available again, as detailed in the announcement of the meeting. I'm joined at the table by the CEO, Mr. Matash, the Executive Director, Mr. Abril, Mr. Secretary and the Deputy Secretary of the Board. The other directors, as well as the company's senior management, are seated in the front rows of this room or attend the meeting by remote means of communication provided for this purpose. By resolution of the Board of Directors, the Notary Public, Gerardo von Wichmann Rovira, here present, has been requested to draw up the notarial minutes of the meeting so that, in accordance with the provisions of Article 203.2 of the Capital Companies Act, it will not be necessary to submit the approval of the minutes to this meeting at the end of the session. The proposal submitted for your approval, determination of the number of directors, appointment of 6 independent directors and 1 proprietary director, amendment of Article 24 of the Articles of Association, and the delegation of powers to formalize the resolutions adopted, comply with the commitments acquired by the Board of Directors following the events of the last ordinary general meeting, to carry out the necessary actions to restore the corporate governance structure so that the Board of Directors of the company has at least 50% of independent directors, and to give each and every one of the members of the board the same voting power. With regard to the proposed appointments of independent directors, I would like to refer briefly to the selection process carried out, which is explained in detail in the proposal report of the Nomination, Remuneration and Corporate Governance Committee, made available to shareholders on the occasion of this AGM. From this process, I would like to highlight the following. The process has been carried out in strict compliance with the company's internal policies and regulations, which in turn are aligned with the good governance recommendations of listed companies. This process has been led by the former independent director, Mr. Martin, and the independent director, Mr. Garcia, as a guarantee that the selection of the new independent directors was carried out with absolute freedom and that their proposal to the board was made with full independence of criteria. I would like to extend at this time and emphasize at this meeting the acknowledgement I made at the board meeting of their professionalism and commitment to completing the selection process. A process that has been complex, both because of its magnitude, given that the process was aimed not at selecting a single candidate, but at recomposing the board of directors, and because of the unique circumstances in which it has been carried out, and which I believe has culminated in a very satisfactory manner for the company. As established in the director selection policy, the CNRGC, on the basis of a competency matrix, established a profile for directors with a global approach that encompasses the different offices and positions to be filled, and established demanding selection criteria that, as far as independence is concerned, go beyond the strictly legal criteria established in the Capital Companies Act. During the process, the Commission was advised by Korn Ferry, a consultancy firm specializing in the selection of independent directors, and the independence of the candidates was further reviewed by Ernst & Young in line with best corporate governance practices. On the other hand, with regard to the proposed appointment of a third proprietary director representing the shareholding interests of SEPI, I would like to point out that the shareholder informed the company that the incorporation of the number of independent directors that would restore the balanced composition required by the Code of Good Governance was a priority. Therefore, the effectiveness of this appointment agreement is conditional on the approval by the General Meeting of the appointment of each and every one of the candidates for independent director, points 1.2 to 1.7 of the agenda. On the acceptance of the position by those thus appointed, and on the board of directors being made up of 7 independent directors representing at least half of its members, again in line with the recommendations of the Code of Good Governance. Finally, the proposed amendment to the bylaws increases the alignment of the internal corporate rules with the recommendations of good corporate governance and will entail giving each and every member of the board the same voting power, which will encourage resolutions to be adopted with the greatest possible consensus. In short, I believe that the proposals submitted to this general meeting allow the company to once again have, in record time, and thanks to the effort and commitment of all parties concerned, a board of directors with a balanced composition that is largely aligned with good governance practices and with the experience and capacity necessary to face the future in the best interest of shareholders and stakeholders. Dear shareholders, I thank you for your confidence in the new phase of the company, which with your approval will open today. Thank you very much. I give the floor to the Secretary. Thank you, Mr. President. Good morning. Ladies and gentlemen shareholders, the Bureau of the Board having been constituted with the members mentioned by the President, I will now inform you of the following matters. The meeting has been duly convened through the publication of the mandatory notice on the company's website and on the website of the CNMV on 26 September 2022, as well as in the newspaper El Economista on 27 September 2022. It is noted that no alternative proposals for resolutions on the matters already included in the agenda have been submitted, nor have any requests for information or clarification been received from shareholders prior to the meeting. I also inform you that from the date of the call to meeting until today, the company has continuously made available on its corporate website all the information provided for in Article 518 of the Capital Companies Act. With regard to the full text of the proposed resolutions, I hereby inform you that they have been formulated, differentiating those matters that are substantially independent, and the notary has been provided with the full text of all of them. An electronic shareholders forum has also been set up on the company's corporate website, to which both shareholders and voluntary associations of shareholders constituted and registered in the special register set up for this purpose at the National Securities Market Commission have been able to have access. Data on the capital attending the AGM so far are as follows. Provisional quorum, present 108. Accounting for 1.325432 shares, representing 0.75% of the capital. 170 shareholders represented by proxy, accounting for some 131,176,699 shares, accounting for 74.26% of the capital. In total, we have 278 shareholders holding 132,502,131 shares, accounting for some 75.01% of the capital of the company. Out of all those shares, 43.5% are shares held by the board, any of its members, and the secretary. We're finalizing the recount of the last cards telematically, so before we start the voting, we will read exactly the final quorum achieved. Thank you very much, Mr. Secretary. Having heard the provisional attendance figures provided by the Secretary, I declare this general meeting provisionally constituted on first call, and this meeting will now commence. I give the floor to the notary. Good morning. Are there any reservations or objections to the declarations regarding the number of shareholders attending or the capital present? I would like to remind shareholders attending telematically that there is a link in the computer application to send any reservations or objections they wish to express to this notary. There's nothing, so I now give the floor to the President. I now give the floor to the Secretary to explain the procedure to be followed in relation to the shareholders' interventions. Thank you, Mr. President. If any shareholder present in the room wishes to speak to request information or clarification in relation to the items on the agenda or to formulate proposed resolutions on those matters which, as permitted by law, need not appear on the agenda, she must inform one of the hostesses present in the room who will accompany him or her to the speaking table. Those who wish to do so may do so from this point onwards. I would ask shareholders who wish to speak to anticipate in the documents provided to them the questions they wish to raise, in order to expedite the development of the round of interventions and of the meeting itself. Likewise, if you wish your intervention to be recorded verbatim in the minutes, you must submit it in writing so that the notary public can check it against your intervention. Shareholders who have given notice of their intention to speak shall do so when the chairman opens the floor. To do so, when they're called from the table, the shareholder must go to one of the microphones installed in the central aisles of the room. After all the shareholders have spoken, answers will be given, if appropriate, from the table or by whomever the chairman indicates. In relation to the shareholders attending telematically, as detailed in the notice of call, they have been able to send their intervention or question through the computer application up to the moment when the chairman provisionally declared the meeting validly constituted, indicating, where appropriate, whether they wish their intervention to be recorded in the minutes of the meeting. In accordance with the provisions of the notice of call, the interventions sent by the telematic attendees shall be answered during the course of the meeting or in writing within 7 days following the holding of the general meeting. We'll now have time for the speakers. I give the floor to the Secretary to give way to the shareholders' interventions. Before I begin the presentation period, I would like to remind the shareholders attending this meeting electronically that they have been able to cast their vote on the proposed resolutions on the agenda from the moment they have connected to the application, and that they will be able to do so until the end of the presentation period in this room. I remind you that in the event that a shareholder or his or her representative does not indicate the direction of their vote through the computer application, it will be understood in any case that they vote in favour of the proposed resolutions formulated by the Board of Directors in each point of the agenda. With regard to the speaking time, and in order to ensure the smooth running of the meeting, we would ask shareholders to keep their interventions as brief as possible and not to speak for more than 5 minutes. In compliance with the information that we have on the table, there's only one shareholder that wishes to speak, José Antonio Díaz Barrio Colmenarejo.
This person is acting in representation of the shareholder named Padre Bernabé S.L. Mr. McMurtra, Mr. Dear Directors, the problem of governance that today has finally been resolved, as the going says, when the dog is dead, the rabies is over, has caused the loss in 5 months of the company of about 25% of its capitalization. As some minority shareholders, I would personally beg the president and all the members of the board to dedicate themselves fully to resolve as much as possible said loss, and that our shares will resume to be quoted at an adequate price. Now, just a very brief question. Mr. Chairman, has the dividend come to stay, or is it just a midsummer's night dream?
Muchas gracias. Cedo la palabra al señor consejero.
Thank you very much. I now give the floor to the CEO. Thank you very much for your question concerning your dividends. Please be reminded that we had a relevant action on October 27, 2021, approving a dividend of 15 euro cents per share paid in the month of July. And I think that this board is always paying attention to the retribution to shareholders and the best way to produce value for the shareholders. And considering the availability of funds and the development of the company, this board shall establish the dividend to be paid. Thank you very much. Thank you, Mr. Chairman. After the round of intervention, I remind the shareholders that they will no longer be able to issue their vote through the online attendance application. I give the floor to the Secretary to report on the final quorum. I would like to inform you that after finishing the counting of cards and attendees by telematic means has been completed, and that the definitive quorum of attendance is as follows, to be seen in the screen. We have present at this meeting 109 shareholders representing 1,327,184 shares, which account for 0.75% of capital. By proxy, we have 170 shareholders holding 131,176,699 shares, representing 74.26% of shares. Overall, we have 279 shareholders holding 132,503,883 shares, representing 75%, 0.1% of the quorum. Thank you very much, Mr. Secretary. At this moment, the list of attendees is closed in the terms informed, and I ratify the valid constitution in the first call of this extraordinary general meeting of shareholders, which may deliberate and adopt resolutions on all the points included in the agenda. Now give the floor to the notary. I repeat the question as to whether there are any reservations or objections to the declarations regarding the number of shareholders attending or the capital present. I would like to remind the shareholders who attend telematically that there is a link in the application for this purpose to send any reservations or objections they may wish to express to this notary. If there are no reservation, I give back the floor to the President. Thank you, Mr. Notary. I give the floor to the Secretary to report on the voting procedure. Thank you very much, Mr. President. I hereby inform the shareholders that in accordance with the proxy procedure approved by the Board of Directors and detailed in the announcement of the call to this general meeting, and those proxies that have been received without a nominative expression of the person in favor of whom they are delegated, or have been conferred generically in favor of the Board of Directors, have been deemed to have been granted in favor of the Secretary of the meeting, who is the Secretary of the Board. Furthermore, in accordance with the provisions of the Articles of Association and as expressly stated in the notice of call, at this general meeting the company has provided the necessary means for shareholders to exercise their voting rights or grant proxies by remote means of communication, which have been duly counted for the purposes of the aforementioned quorum of attendance. As detailed in Section 4.4 of the Notice of Call and as indicated by the Chairman, the shareholders attending the meeting by electronic means have been able to cast their vote from the time the shareholder has registered in the electronic attendance computer application until the end of the voting session in these premises by means of the voting procedure set up in the aforementioned computer application. Likewise, in the case that the shareholder or his representative has not indicated the direction of his vote with respect to the resolutions in the agenda, it is understood that he votes in favor of those formulated by the Board. As mentioned in the notice of call, for the purposes of the provisions of Articles 5 to 3, we will establish the rules in the call to meeting in case that the agreements made different to those formulated in the Board of Directors. As required, the results of the voting shall be recorded in the minutes of the general meeting and shall be published on the company's website within the period established for this purpose in Article 525 of the Capital Companies Act. For the counting of votes, only those shareholders present in the room who wish to vote against or abstain on the different points of the agenda proposed by the Board must approach the voting table set up for this purpose at the back of this room so that they may be identified and their vote may be recorded. Otherwise, it shall be understood that they vote in favor of the proposed resolution formulated by the Board. The shareholders who, in accordance with the above, have not yet cast their vote and wish to vote against or abstain on any of the items on the agenda proposed by the Board may please approach the voting table at this time and cast their vote. Pursuant to Article 197 of the Capital Companies Act, separate votes will be taken on each of the various proposals for the appointment of directors contained in Item 1 of the agenda. It is noted that there have been no requests for a vote on resolutions other than those included in the agenda of the call. Therefore, we proceed to the vote of the proposed resolutions on the agenda. In order not to excessively prolong the duration of the meeting, and given that the full text of the resolutions to be voted has been available to shareholders from the time the meeting was called, it is proposed that this text be read out with only the wording of the agenda item to be voted on. Are there any objections in this regard? As no objection has been raised, I will therefore not read out the full text as indicated. The following is a summary of the content of the resolution submitted for the approval of the general meeting. The first item on the agenda is the vote on the proposal to determine the number of directors and the appointment of the directors to be indicated in the respective votes. The second point is to vote on the amendment of Article 24 of the Articles of Association to remove the casting vote of the chairman of the board of directors. And finally, the third point will be to vote the empower the chairman, the secretary, and the deputy secretary of the board to formalize, register, and execute the resolutions adopted by the general meeting. Once the content of the proposed resolutions have been read out in summary form, the votes cast on each of the proposed resolution on the agenda are counted and the results of the votes are announced.
Punto primero, determinación del número de consejeros.
Point 1, determination of the number of directors. According to Article of 917 of the LSC, the proposals included in this item on the agenda are voted on individually and separately. Point 1.1, determination of the number of directors. To set the number of members of the board of directors at 14, within the minimum and maximum limits established in Article 21 of the Article of Association. In accordance with the information it is provided to this Bureau, it is approved by sufficient majority. In favor, we have shares representing 99.9% of the company capital. Accordingly, this is approved by sufficient majority. 1.2, appointment of Mrs. Belén Amatreina Corby as an independent director. In accordance with the information provided to this Bureau, it is approved by sufficient majority. In favor, shares representing 99.82% of company capital. Therefore, this approved by sufficient majority. I would like to explain that after each appointment, we will request each member of the board to formally accept the post. Mrs. Amatrein, do you accept the post to which she has been appointed and declare that she is not affected by any of the grounds of incompatibility? Yes, I do. Thank you very much. Appointment of Mrs. Virginia Alce Peralta as an independent director. In accordance with information provided in this Bureau, it is approved as follows. Voted in favor, shares representing 99.82% of company capital. Therefore, this appointment is approved by sufficient majority. Mrs. Arce, do you accept the post to which you have been appointed and declare that you are not affected by any of the grounds for incompatibility established in current laws for holding the post of councillor? Yes, I do. Thank you very much. Appointment of Mr. Axel Joaquim Arendt as an independent director. In accordance with the information provided to this Bureau, the data on this proposal are as follows. Voted in favor, shares representing 99.42% of the capital present or represented in this room, so it is approved by sufficient majority. Mr. Arendt, do you accept the post to which you have been appointed and declare that you are not affected by any of the grounds for incompatibility laid down in current laws for holding the post of director? Yes, I do. Thank you very much. Appointment 1.5, appointment of Mrs. Coloma Romero Montes as an independent director. In accordance with the information provided to this Bureau, it is the data on this proposal are as follows. In favor of the appointment, shares representing 99.52% of company capital. And therefore, it is approved by sufficient majority. Mrs. Armero, do you accept the post to which you have been appointed and declare that you are not affected by any of the grounds for incompatibility laid down in current laws for holding the post of councillor? Yes, I do. Thank you very much. 1.6, appointment of Olga San Jacinto Martinez as an independent director. In accordance with the information provided to this Bureau, the data on this proposal are as follows. Voted in favor of this appointment, shares representing 99.82% of company shares present or represented in this meeting. So it is approved by sufficient majority. Mrs. San Jacinto, do you accept the post to which you have been appointed and declare that you're not affected by any other ground for incompatibility laid down in current laws for holding the post of councillor? Yes, I do. Thank you. Point 1.7, appointment of Mr. Bernardo Villasangil as independent director. In accordance with information provided to this Bureau, the data on this proposal are as follows. Voted for the proposal, shares representing 92.83% of represented capital, so it is approved by sufficient majority. Mr. Villasan, do you accept the post to which you have been appointed and declare that you're not affected by any of the grounds for incompatibility laid down in current laws for holding the post? Yes, I do. Thank you very much. Finally, 1.8, appointment of Mr. Juan Moscoso del Prado Hernández as propriety director. In accordance with information provided to this Bureau, it is the date on this proposal for agreement are as follows. Votes in favor of the appointment, shares representing 76.73% of the present or represented shares in the meeting. So it is approved by sufficient majority. In relation to this proposal, the remaining conditions to which the effectiveness of this resolution was subject have been fulfilled, as the appointments of the independent directors, point 1.2, 1.7, have been approved by this AGM, and they have all accepted their post. Therefore, Mr. Moscoso, do you accept the post to which you have been appointed and declare that you're not affected by any of the grounds for incompatibility laid down in current laws for holding the post of director? Yes, I do. Thank you very much. Now we go to a second point on the item of the agenda, which is approval of the amendment of Article 24 of the Articles of Association to eliminate the casting vote of the chairman. In accordance with the information provided to this Bureau, the data on this proposal are as follows. Votes in favor of this proposal, shares representing 99.98% of the capital of the shares that are present or represented. Therefore, it is approved by sufficient majority. And finally, point 3, authorization and delegation of powers for the formalization, registration, and execution of the resolutions adopted by the board. In accordance with the information provided to this Bureau, it is approved the data for this proposal are as follows. Votes in favor, shares representing 99.98% of the shares that are present or represented at this meeting. Therefore, it is approved by sufficient majority. Now I give the floor to the President.
Thank you. In view of the result of the votes just taken, all resolutions submitted to this meeting are declared formally adopted and the meeting is adjourned. Thank you very much once again for your participation and trust.